Good morning to all the participants and the esteemed social workers of Ontario. Thank you for gathering here today for this MASWO hosted webinar on social work in correctional setting. As we delve into the crucial realm of social work in correctional settings, your presence here is also a shared commitment to making a positive impact in the lives of those within the justice system. And it is both commendable and vital. Today, let us explore innovative approaches, share experiences, and foster collaboration. As social workers, your dedication to rehabilitation and societal reintegration is a beacon of hope. Let us use this platform to strengthen our collective efforts and contribute to the betterment of our communities. Also, we are very happy to have an eminent guest list who have been in the field for the last many years, and they have been kind enough to spare time from their busy schedule to be with all of us. So a hearty welcome to each one of you once again. Before we start, may I request Deepa Lal to do the land acknowledgement, please?
In the spirit and intent of the Truth and Reconciliation Commission's recommendations, we acknowledge the traditional Indigenous territories on which we gather at the beginning of all MASWO sessions. We would like to begin by acknowledging that the land on which we gather is the traditional territory of the Wendat, the Anishinaabe, the Haudenosaunee, Métis, and the Mississaugas of Scugog, Hiawatha, and Alderweil of First Nations. By learning, understanding, and acknowledging, we wish to pay respect to the Turtle Island, Mother Earth, and to the rich Indigenous history of Ontario.
Thank you, Deepa. Thank you so much. As we go into the session, allow me the privilege of introducing our first speaker for the day. It is Abby Thomas. He works as a mental health practice lead advisor with London Intercommunity Health Centre. Abby has experience working with various provincial correctional facilities in Ontario. He has worked as a social worker with the Maplehurst Correctional Complex and Toronto South Detention Centre, and also worked as a social work supervisor with Ontario Correctional Institute, Brampton. Abby holds a master's degree in social work and is a pass out from the eminent Indoor School of Social Work. He also is a very good badminton player of note. So over to Abby.
Good morning, MASWO members. Thank you, Varghese, for the introduction. Thank you for joining the first part of our session about correctional settings in Ontario. In this presentation, I will try to provide an overview of some basic information on Ontario's judicial and correctional system. The presentation won't be a comprehensive one explaining every details of correctional system or judicial system. I will try to provide a basic information within the stipulated time allowed to me. The first thing I want to talk about is the rule of law. I think we must have heard this term, the rule of law, many times, probably over a couple of years. This is a basic fundamental principle that guides the Canadian justice system and the democracy. It is also outlined in the preamble of Canadian Charter of Rights and Freedoms. So basically, it says that every individual is equal before the law, irrespective of their caste, creed, color, sexual orientation, position, power, and authority. So it guarantees each and every citizen of Canada the opportunity to stand equally before the law whenever they are alleged to commit a crime. So when it comes to Canada, when it comes to Canada, the provincial, there are a couple of things we need to know that. Criminal Code of Canada, Charter of Rights and Freedoms, provincial regulations are the guiding principles in related to arrest, detention, trial, and sentencing and rehabilitation of offenders in Canada. And Government of Canada, laws are enacted by the 3 levels of government: federal, provincial, and municipal. Government of Canada, the federal government has authority under the Constitution to enact any statutes of Canada, including criminal code. And each province, under the Constitution Act, each province is allowed to create provincial laws. For example, child protection, in the areas of child protection, consumption of liquor, traffic laws, and family law. These are some of the provincial legislations that each provinces are allowed to create their own laws. The provincial laws may differ across the country. For example, the legal drinking age in Ontario is 8, in Ontario is 19, whereas in Alberta and Manitoba it is 18. And within Ontario, each municipalities, for example, the City of Toronto, they are allowed to create their own laws. It's called bylaws or municipal codes. So, for example, I would say under the Provincial Highway Traffic Act, the speed limit to drive on any street in Ontario is 15. But when you look into some of the streets in our province cities, you would see speed limit is limited to 30 or 40. So that limitation is allowed under the municipal codes or municipal bylaws. Next slide. So now I'm going to talk about the types of offenses. There are 3 types of offenses in Canada. When you are criminally charged with an offense, you will be an individual will be charged with either one of these 3 offenses. The first one is the summary offenses. These are the least serious types of offenses. One example would be driving under the influence, or other one would be sexual assault. The second one is the most serious types of offense. This is indictable offense. One example would be first degree or second degree murder. And the third offense is the summary offense. These are the third one would the hybrid offense. A hybrid offense can be treated as either a summary offense or indictable offense based on the discretion of the public prosecutor or the crown prosecutor. So, for one example, driving under the influence is a summary offense, but if there is an injury to an individual or additional harm caused by this of driving under the influence offense, then the crown can decide to proceed that as a hybrid offense, or as a indictable offense. Next slide, please. So in Ontario, the judicial system is managed by Ministry of Attorney General. The Ministry of Attorney, they are responsible for providing a fair and accessible justice system that reflects the need of the diverse communities it serves across government and the province. It also strives to manage the justice system in an equitable, affordable, and accessible way throughout the province. So the Ministry of Attorney General is responsible for maintaining the courthouses and arranging all the activities associated with a court or criminal justice system in Ontario. So now I'm going to talk about the criminal proceedings. What happens when an individual get into conflict with the law or get into contact with the police? According to Canadian Charter of Rights, anyone charged with a crime is presumed innocent until proven guilty beyond reasonable doubt, and the Crown or the state bear the burden of establishing such guilt. So what happens when an individual criminally charged? So what happens when most of the times police charge an individual? So when police arrest an individual, there are certain charter rights that must be enforced by the police. The first one, the police has to tell an individual why they are charged or arrested or being detained. The second one, the police has to inform the individual that they have the right to remain silent. And the third one is the police has to inform the individual that they have the right to legal counsel. Normally, when an individual gets charged, depending upon the seriousness of the crime or the type of offense they are committed, the police has the authority to release them with a promise to appear before a judge for their next court appearance. So police would release an individual with that undertaking. So every person under Canadian Charter of Rights and Criminal Code has a right to a bail and right to not to be unreasonably detained without a just cause. So police or criminal justice system they have to always respect that charter rights. So in some cases, depending upon the severity or nature of the offenses, police won't be able to release that individual. If an individual poses significant threat to the community or the victim, police has to detain them for a bail hearing before a justice of peace or a judge within a reasonable time. Normally in Ontario, that is 24 hours. So if an individual doesn't get a bail from the police station, they will be produced before a judge for the bail hearing. And the individual, if the individual doesn't have a lawyer, they will be represented by a duty counsel provided by the state. And there will be a bail hearing. Then after hearing, the public prosecutor as well as the duty counsel argument, the judge will decide whether individual is granted bail or not. If not, the individual will be sent to a detention center. That's how they enter a jail. So when an individual is denied bail and sent to a jail, then that individual is called a remand custody inmate, and most cases they will remain as a remand inmate in the Ontario provincial jails, most likely until they finish their trial. So in some cases, if an individual believes that there is an opportunity I can get bail because the judge or my lawyer didn't do a good job, they have an opportunity. Or if they have some circumstances changed, they have an opportunity to review their bail in a superior court, but it's a lengthy and a laborious process. Oftentimes, it takes a lot of time. So other option is a bail variation. So oftentimes what happens, people, when they get bail from the police station or from the judge, they normally don't worry much about the conditions, but sometimes they feel like after getting bail, they only realize that that is creating significant barriers to their freedom. So they can go back to superior court and ask for bail variation to make some relaxations in their bail conditions. Apart from that, there are other programs that also allow people to get bail, or that will allow people to not to spend their time in jail. That's the court diversion program or mental health diversion program. The court diversion program is an agreement between the public prosecutor and the accused. They would agree for a certain period of time to exhibit certain behavior, good behavior. And normally in Ontario, that is 1 year. These options are only available for summary offenses, and the public prosecutor would agree for that an individual to show certain behavior or remorse towards their offenses, and that will be normally for an year in Ontario. And if individual complies with all conditions set out in the court diversion or mental health court diversion program, their charges will be suspended, or the case will be stayed. Next slide. Apart from that, there is also another program that's called the bail program. You can see the bail programs in almost all courts in Ontario. So this bail program is for people, those they do not have a surety, or they don't have anyone to be a surety for them to get bail. So in this case, if the public prosecutor agrees with this, then only for summary offenses, the individual can for a bail program, where the individual has to agree with the conditions of a bail program, like meeting with a bail supervisor on a consistent basis and complying with all other conditions set in a bail program. So if an individual violates the bail program, such like they do not meet with the bail supervisor or any other conditions, they will be charged, their bail will be revoked, and they can be brought back to the jail. So during the trial process, people plead guilty or contest their charges. If they plead guilty, then the trial process will continue and they will be sentenced. If successfully contested or defended, when Crown could not prove beyond the reasonable doubt that someone has committed a crime, the accused will receive a complete acquittal and charge will be dismissed. There won't be any criminal record, anything. Next slide, please. So if an individual is found guilty, will get sentenced depending on the type of offense and the remorse the individual showed during the trial process and all the mitigating factors. So sometimes people will get absolute discharge or discharge. Even though the judge found an individual guilty, judge can decide that an absolute individual only needs a probation. So the judge would decide an absolute discharge or discharge of the offense is suitable. So they would get out without serving any jail time with a probation. Normally, it's up to maximum 3 years in Ontario. Sometimes they will get a suspended sentence. Judge finds them guilty, but they do not get a sentence. They do not need to serve a time, but instead of, they will be asked to abide by some conditions in the community. Sometimes they will get a conditional sentence. An example would be a house arrest where they have to remain in a defined place for a certain period of time, and certain curfews will be imposed on them on top of some probation. Probation is associated with most of this absolute discharge or suspended sentences, conditional sentence, where they will be asked to work with a probation officer in the community and maintain the good peace for a certain period of time. If they don't get any of these sentences, they will be sentenced to a provincial or federal institution. The provincial sentence is 2 years less a day, and the federal sentencing is 2 years plus maximum up to 25 years, with or without the eligibility of parole. Next slide, please. So another scenario we come across when we deal with the criminal justice system is that not criminally responsible. Under Section 16 of the Criminal Code of Canada, it is a fundamental principle of the Canadian criminal justice system that an accused must possess the capacity to understand that their behavior was wrong in order to be found guilty of an offense. So whether an individual is stable or not, it is a process whether it determining that whether the individual was in a sound mind when he committed an offense. So if an individual, it applies mostly to the people struggling with the mental health challenges, severe mental health challenges, I would say. So when a person with mental health, severe mental health challenges committed an offense when they were struggling with their mental health challenges, they would most likely deemed not criminally responsible in Ontario. So if a court, after many processes, it's not an easy process. Sometimes people think that, okay, I'm going to plead NCR, but the process is very rigorous and they have to go through the various assessment uh, in Ontario. And if even after that, if the court finds that this person is not criminally responsible, they will be sent to Ontario Review Board for follow-up. And Ontario Review Board is the statutory body in Ontario responsible for managing people who are found not criminally responsible or unfit to stand a trial. In some cases, when people are found not criminally responsible, they will be sent to community with certain conditions to serve, to live, most likely to attach to an ACT team or a community treatment order, or in some cases, if ORB believes, Ontario Review Board believes that the individual poses a threat to the community, they will be detained. They will be detained in a forensic psychiatric unit in a hospital. Another one is that another scenario is unfit to stand trial, where an individual during the trial process is not able to comprehend what is happening in the trial process. Criminal Code 67222 states that an accused is presumed fit to stand trial unless the court is satisfied on the balance of probability that the accused is unfit to stand trial. So the individual, whether he was when he was committed a crime, probably the individual was in a sound capacity, but at this time of trial, because of various factors or because of their mental health, they do not understand what is happening, or they don't have the mental capacity to understand the trial process. According to Criminal Code of Canada, the court has to declare that individual unfit to stand trial. In this case, also, if a court find that the individual is unfit to stand trial, the court can send that individual to Ontario Review Board to follow up with their remaining sentence or the custody. Apart from that, in Ontario, and people are eligible to get a parole in Ontario once they serve 1/3 of their sentencing, or at least they must be sentenced to for at least 6 months sentencing. If you are sentenced to less than 6 months and you want to get a parole, you have to write a letter to Ontario Parole Board to consider that individual for parole. Otherwise, it is an automatic process guaranteed under Canadian Charter of Rights and Criminal Code of Canada that any individual sentenced to Ontario jails more than 6 months to less than 2 years are eligible to get a parole. And in federal institution, any individual who are sentenced to a federal sentencing that more than 2 years is eligible to get a parole once they serve 1/3 of their federal sentence. Next slide, please. Now I'm going to briefly talk about the correctional system in Ontario. There are 3 types of correctional institutions in Ontario. The first one is the federal institutions. They house offenders they are sentenced to more than 2 years. And provincial institution, these are the provincial jails or detention centers. This is where the criminal justice system keeps offenders. They do not get a bail. They are remand inmates or sentenced to provincial sentencing. That's less than 2 years at time. And we have youth facilities where we deal youth. They come in conflict with the criminal justice system or law. And we also have parole and probation officers, both federal and provincial, to manage offenders in the community. Next slide, please. Federal correctional institutions in Ontario. This is managed by Correctional Services of Canada under a federal government. And any individual who is sentenced to more than 2 years go there. In Ontario, there are 8 federal institutions, 7 for men and 1 for women, and 1 treatment center at Millhaven, Ontario. This treatment center is also act as an intake center for federal men offenders. And apart from that, there are federal parole officers, community correctional centers, and halfway homes where they manage federal offenders, those who are on probation. Next slide, please. Provincial correctional system in Ontario. It is managed and operated by Province of Ontario. And there are 2 types for adult offenders. Adult offenders means of anyone who is committing an offense who are over 18 years age. And these institutions are managed by Ministry of Solicitor General. And the second one is for young offenders who come into conflict with the law, who their age is 12 years to 17 years old. And these institutions are managed by Ministry of Children, Community and Social Services. So under Ministry of Solicitor General in Ontario, there are 6 correctional centers, mainly keep sentenced inmates focused on rehabilitation, and 8 detention centers, mainly keep remand inmates focused on detention and management, community reintegration and rehabilitation of short-term offenders. And when an individual is denied bail, they normally come to detention centers or jails. There are 8 jails in Ontario. These are smaller facilities, normally in a remote areas, keep remand inmates. Inmates frequently move to other facilities from there. Apart from these detention centers or jails, there are 3 specialized treatment centers that provide intensive treatment to sentenced offenders in Ontario. The first one is Ontario Correctional Institute in Brampton. They provide offense-specific treatment to sentenced offenders, mainly for criminal and sex offenders. Individual can apply once they are sentenced to come to these institutions through the classification department in their respective institutions to come to any of these treatment centers, or sometimes it is a condition attached to their sentence that they have to spend time in these treatment centers. The second one is St. Lawrence Valley Correctional Treatment Center, Brockville, Ontario, provide treatment and rehabilitation for sentenced offenders with the mental health challenges. And the third one is Algoma Treatment and Remand Center, Sault Ste. Marie, provide treatment to sentenced offenders struggling with the substance abuse, domestic violence, and criminal lifestyle. Probation and parole officers, this is the community arm of Ontario Correctional System. So in Ontario, there are 121 probation and parole officers. This is managed by Ministry of Solicitor General. And these probation officers are exclusively to manage provincial offenders. So the probation officers do supervision, management, and rehabilitation of offenders in the community through. Yeah, next slide. Next one is a concept, restorative justice. This is going to be my last slide. And restorative justice is a system of criminal justice which focuses on the rehabilitation of offenders through the reconciliation with the victims and the society at large. So that the restorative justice approach envisages a system where everybody, the offender, understands the harm they've done to the victim. At the same time, society has a responsibility to keep the offenders as much as possible in the society, and it's also focused on the institutional of our correctional institution. And Ontario is in the process of revamping its Correctional Services Act to become it more rehabilitation focused. Currently, the correctional services in Ontario is more institutional focused and punitive in nature, but the more progressive revision of the law is looking for a system that is more focused on offender rehabilitation. Thank you for listening, and looking forward to any questions at the end of our session.
Thank you, Ebi. Thank you for throwing light on the levels of governance, the type of offenses, the judicial system, the proceedings. I'm sure this all are very helpful. We will go to our next session, and that would be led by the special speaker for the day, Mr. Abhilesh. He serves as a social worker at the Maplehurst Correctional Complex in Milton and has also worked at Toronto South Detention Center. Abhilesh's passion for community service exceeds beyond borders. He has worked across boundaries in Toronto, and while being in India, he held the position of a national program manager at the Catholic Bishops' Conference of India in New Delhi. Abhilesh is not only a social worker, but he's a published researcher as well. His work, titled A Holistic Approach to TB Prevention and Cure, which was a study done in Jabalpur, MP, was featured in the International Journal of Tuberculosis and Lung Diseases, the Union Volume 19. You can refer to if you want to. This groundbreaking research was presented at the World Lung Conference in Cape Town, South Africa, showcasing Abhilesh's commitment to advancing knowledge and addressing critical health issues. He also is an MSW from Indoor School of Social Work, apart from being an alumni of ISW program at the erstwhile Ryerson. There's a fun fact of Abhilesh. He also is a human being like us. Abhilesh plays the guitar and enjoys working on creative design projects. Abhilesh will be sharing on rehabilitation program in correctional setting. Thank you, and over to Abhilesh.
Thank you, Varghese, for the extra fun facts and information. I'll be sharing my presentation. So today we'll be looking into rehabilitation programs in correctional setting. I thank MASWO for this opportunity. So we see that 22% of inmates were homeless at the time they were arrested, and 85% anticipated being homeless again upon discharge. This is a study done by John Howard Society called Broken Records. And we are going to see what happens when an inmate comes into in institution, from the intake till the time he gets into an unit. So the first important thing is when he reaches, his identification and documentations are checked. And after that, there's a search procedure where he goes through a proper scan. And if he's fine, he goes into an intake unit, or it could be, sometimes into a dry unit if he doesn't pass the scan. And then we have a health assessment. So admit and discharge unit has a nurse who does the health assessment, makes sure that all the supports he needs are um, dealt there. And after the initial health assessment, there's an opportunity for the social worker to do and jail assessment, where we identify does he has any suicidal thoughts, or any mental health background where he needs specific attention from the health team in the institution. And as per the classification officer, he's classified into which unit he will go. It could be a special needs unit, or it could be a segregation, or it could be a general unit where he could be going based on the classification. Then he's given orientation about the institution, where he is and how things are going to be for him. And his personal property are kept in a separate bag, which will be given to him when he gets released. We have a special identification number for the bags, and everything he brings in to the institution are kept there very, very safely. And we have a place when he get discharged, he will be getting that. And he gets support with communication, and he can also purchase a phone card where he could contact with his family and friends and the support he has in the community. And most important thing is the legal rights. He has opportunity for legal aid. If he needs support with legal aid, he is given that support here. And as social workers, we also try to connect them with legal aid services. If they don't have such kind of services, most of them might have a lawyer already who is working with them. But we always try them that they are connected to legal aid, specifically someone with mental health, and someone who is like eligible to go for legal aid. One important factor is the health team, where we have doctors, nurses, mental health nurses, chief psychologists, psychiatrists who work as a team to support the inmates. And we also have a program team where we have social workers, volunteer coordinators, addiction workers who will be working together. And every week we have the multidisciplinary team coming together to check, for example, the doctors, mental health nurses, deputy superintendent of the programs come together, the social workers, addiction counselors, chief psychologist, social work manager. So here the social work manager has a different role, because social work manager is not only managing the social workers, but he could be heading the programs department. Every institution has a different style of doing it, but social work manager has like broader perspective here. And also, I see that librarian is an very important role, because many of the books what they need are provided by the librarian, and make sure that different language services are there. Like always, we are looking for people who could donate books for us, specifically languages like Punjabi, Urdu, Hindi, where we need more donations, because the publications are not available to purchase many times. They try to contact the local gurudwaras, local places where they could get it. Amazon also they try. So any book donations, always they are welcome. So another small activity for everyone to make sure that everyone is with me. What color is commonly associated with inmate clothing in a correctional facility? You can put in the chat. It could be blue, orange, green, burgundy. Maybe Varghese can look for me in the chat. Your time starts now. You have some 1 minute maybe to answer it. Which color do you think goes with an inmate here in Ontario and Canada? Do you think it's a blue color or orange or green or burgundy? I need at least 47 responses for this. So I'm getting a lot of colors like blue, B, orange, orange. Yeah. Thank you for your responses. So most of you are right. So the orange color goes for the men inmates. Specifically in Ontario, we use orange for the men, and green we use for the women in the women jails. And burgundy, any guess, anyone? Who wears burgundy? Do we have any chats? Okay, so Sonia is saying woman purple or green. Jinto is saying children. Yeah, very close. So I was also not aware about this. Anu told me recently that youth wear burgundy in their institution. So that's also new for me, because I always, when I think about a client, I always think about in orange. But someone who is transgender, he has an option to wear green also. They are given the option, if they identify as a transgender, they could wear either orange or green in a men facility or in a female facility. And mainly in the female facility, we have green. Thank you for your participation. I'm sure that you're listening to me. Another important thing, like dog therapy, many times we hear that because our social workers, our program teams are doing so much, there's a lot of burnouts, and specifically also for inmates, it's hard because they are in the institution. The St. John's Ambulance Therapy Dog Program reaches out to thousands of people on a daily basis, bringing comfort, joy, and companionship to members of the community. Program participants reap the therapeutic benefits of the unconditional companionship of a four-legged friend through petting, affection, and regular visitation. Many people benefit both physically and emotionally from the unconditional love of a dog. So this is something new happening in our institution, where every week we have the therapy dogs coming in, and we have a wellness room where they come. Maybe we have 3-4 dogs coming in with the volunteers. The staff can go with them, cuddle with them, hug them, play with them, talk to the volunteer, the story, how the dogs were, how they get connected, how they were escaped from different places, and there are different stories. And also inmates gets opportunities to spend some time with the therapy dogs. But right now we are doing it more for the program staff and the correctional officers, because there's a lot of it's a difficult job what they're doing. Another important thing, that food. So these are the few foods which are provided in an correctional facility, like halal. If they're from the Muslim community, they could ask for halal food. If they're from the Jews, they could ask for kosher. And if someone is vegan, they can ask for vegan. Like some people like Sikh, they prefer vegan, and some people prefer vegetarian. And vegetarian, sometimes they could also add in some eggs sometimes. And for halal and kosher, you need to get in contact with the chaplain, and vegan need to contact the chaplain or the imam, who will be helping them to identify food according to their religious belief. But if it is something related to the medical issue, if there is some allergies or anything like that, So the nurses and doctors will be making sure that they are getting treated fairly in the institution. This is a very small example of the values of the correctional system in Canada, which is respect, fairness, professionalism, inclusiveness, accountability, making sure that everyone is treated with dignity and respect and given the culturally appropriate uh, food, which is in one example which I'm showing it today, because this is also part of their physical, mental, and spiritual care, which is provided in an institution. So we are talking about chaplaincy. Chaplaincy is also an important function where the inmates are provided with spiritual care by the chaplaincy from all the religions, all the religion volunteers we have who are coming in on a weekly basis from different religions. And chaplaincy, we have like imams from the Christian denomination, like from Sikh, different denominations we have who support them with their spiritual care. Also, someone who needs elders from the indigenous community or also given the support. So these are some programs which are conducted by chaplaincy for the inmates, like for addictions, grief recovery, self-esteem, relationship, codependency, forgiveness, grief recovery. So as I said, when there's a death in the family, the chaplaincy will be announcing the death after verifying that with the inmate and with the help of social workers and other program team, that they are supported well during that time of grief. Another pilot program what the corrections is doing for around 2 years is now addiction counselors, where addiction counselors are working with the inmates, helping them come out of their addictions. I was just talking to a client yesterday, and he told me alcohol is the reason why I'm here today. So addiction counselors are doing a very good job because they are able to help them, connect them into treatment centers, specifically doing their intake, referrals. We have different treatment centers where they are getting in admission after the exit. Specifically, what happens is when they don't get into a treatment, if they have addiction issues, there's high chances they come back, because when they are in the community, they are looking for money to get the addictions, alcohol, it could be drugs, and they might come back ending up. So I think if we are able to admit them into treatment centers, specifically like Ottawa, we have treatment centers. We have treatment programs happening from like a month to 3 months. There are different treatment centers they could try, and also indigenous people have a different treatment center. Segate, where they get admission for. And another important program what we do for in our institution is the educational session, and this is done in person, and also we do sometimes through booklets after COVID, because sometimes we don't have enough staff or we don't have a program room. So we also do it through the workbooks, and also we have sometimes group with these inmates. So majorly what we cover during these sessions are substance use, anger management, supportive relationship, goal setting, thoughts to action, problem solving, managing stress, use of leisure time, maintaining employment, discharge planning, changing habits, gamble, effective father, budgeting, healthy relationship, understanding feelings. These are the some important components which are provided to the inmates, which add up to their life skills. And after these sessions, they get a certificate. Many of the times I see inmates want to send them to the lawyers. So when they go to the court, they can always present it. They're working on themselves, they're getting changes. And I see there's a good impact of this sessions, the content what is provided to them. Many things what they might have not learned in a community or in a daily setting. They are provided with this support where they're able to getting prepared when they get out. They are mentally, physically, spiritually ready to reintegrate into the uh, community. And many times I also see, one time one inmate told me, I would like to send it to my family. They would like to share the joy that they are doing something creative, they are doing something constructive. They want to share that with their family, that they are trying to be they're trying to change themselves, they're trying to learn new stuff. Sometimes they like to send it to their mother, uh, things like that. So it's an programs always helps in an institution setting. Another program what we do is specifically for changes, is a choice specifically for substance, connections, anger management, and healthy relationship. These are 5 to 6 sessions each. Another important thing what we're doing for the festive season is art competition, which we are doing it right now in our institution. We are giving papers and crayons, and we are given a theme, and they are working on it. They are making different images, different pictures, and that they had a last date this month, and they're submitting. I see a lot of participation. People are taking colors, getting the papers. There's a lot of excitement. People asking for printouts. So there's a lot of constructive time. They are able to do creative. So our deputy superintendent of program is very much interested in such events, and whoever will be getting the prize will be given something from the canteen. So canteen is also something very important. Like they could purchase some of their hygiene stuff. They could get some stuffs which they need for the daily use. Also, they could buy it from the canteen. And there's a trust account where the family could put some money where they could use it for making phone calls or purchasing something from the canteen. So I feel the art competition is a very creative way of engaging the inmates when they're inside. So another important factor when they come into the jail is when they want to get connected to the lawyer. Many times they don't know who is their lawyer, or they just know the name, they don't know the number. So what social workers do is we call the lawyer and book an access to defense call, and lawyer connects an access to defense call with the institution. Most of the institutions in Ontario has access to defense call, but I think few doesn't have it. And also there is professional visit they could have. They could have family visiting them. They could have community visits like the social worker or a bail program worker. So there are a lot of things where they could get involved. So John Howard Society, in one of their documents, said courts and bail, most people with mental health issues go through the regular court process despite needing more treatment-based options. Accessing bail is a challenge. And when they are released, people with mental health issues are often given conditions that are difficult to adhere to. So we are looking at preparing for release. As we were discussing initially, the preparation for release happens the day they have the intake. If the intake day, we need to start thinking about release, that how they are going to reintegrate into the community, how, what are the services they could be provided with. It's most important that they are reintegrated into society. And another statement from the broken records from the John Howard Society says jails are not designed to provide care to people with mental health issues. Conditions associated with incarceration can create mental health issues or make existing issues worse. So these are some of the things what we go through them when they're getting discharged. Most of them get a discharge package, and most of them say that they would like to self-connect with the resources given to them. So every city we have a bunch of resources which is given to them where they can connect with them. but we also try to connect them with different services. Like if they are going to a particular city, for example, they're going to Kitchener, we try to connect them with the food bank there. If they don't have housing, emergency shelters are given connected to them. Housing they would like to take. But another interesting factor, what I see is that most of the time shelters are full, but they prefer a particular city and they would like to go there. They don't like to go a new city or somewhere like that. So they want to go to the same city because they know the people there and they know how it works and things like that. And also, we connect them with financial assistance, employment services, adult learning, specifically if they need to complete their school grades. We connect them with different schooling programs where they could finish their schooling credits when they are in the institution. And we get a lot of donations of clothing. And when they get out, if someone is getting in during the time of summer and getting out during the time of winter, there are different clothing options which they could select from. What the donations, what we get, the community supports us on that. And there are different justice programs run by like CMHA, John Howard Society, who helps us with the bail program and justice programs. And when they get out, there are different settlement services what they connected with. And we also have directly working with the ODSP and Ontario Works. And when they want to be released and they want their account to be activated, we connect them to them. And most of them, they would like to do it by themselves. They know their worker, they know how much they're getting and what's the plan and things like that. They don't want us to get involved sometimes, but if they want, like someone with mental health and any special needs, we also try to help with them. Homelessness. After jail, homelessness is what awaits many individuals with mental health issues exiting jail. Connecting returning individuals to services and support is crucial to preventing homelessness, reducing recidivism, and in increasing public safety. So, as social workers, it's important that we come together, advocate, and build more affordable housing, more shelters, more places where the clients could come and stay. So as community partners, I invite you that we need to work on places, advocate together that we could help them, that they are not back in the system because of their addiction or their homelessness or different because they are not employable. One reference I would like to share, which I was using, was Broken Record, that is published in 2021 by John Howard Society. Thank you.
Thank you, Vilesh, for a very comprehensive presentation. And you covered the therapeutic services, the food choices, the role of the chaplains, and the counseling programs, the treatment plan, the discharge planning. I think these are all very crucial aspects. And thank you so much for your comprehensive insights onto this. So as we move on, our third session would be on overview of youth justice divisions. And we have a very eminent speaker today in our guest list, and it is Anu. She has completed her master's in social work from Rajgiri College of Social Sciences in 2001 and is a registered social worker with more than 12 years of experience working with at-risk youth and their families, addressing problems related to addiction, mental health issues. Anu has experience with psychosocial assessment and intervention, counseling and crisis intervention in the child, youth, and family welfare setting. Anu is also alumni from the ISW program of TMU, the Ryerson University. And upon completion of her program, she joined the Peel Children's Center as a child and family clinician with the intensive treatment services. Anu joined as a social worker at Roy McMurtry Youth Justice Service Division under the Ministry of Children, Community and Social Services in 2020 and continues to work in the youth system up until now. Her passion is to work with youth and their families. Over to you, Anu. Please unmute yourself.
Thank you. Thank you, Varghese, for the warm introduction. I also thank MASWO for giving me this opportunity. So good morning, everyone. As Varghese mentioned, I will be giving an overview on the youth criminal justice system. So the topics covered will be the law that governs youth criminal justice system, principles of YCJA, differences between youth and adult criminal justice system, some terminologies we used in youth justice system, sentencing process, youth records, programs available at youth justice facilities, and finally the role of social workers at youth criminal justice system. So the main law that outlines how to deal with youth who are accused of a crime in Canada is Youth Criminal Justice Act. Children under the age of 12 cannot be charged with a crime. If a child under the age of 12 is caught doing something illegal, the police will likely inform their parents, who can then get help from a child's school or community organization. So this act came into force in 2003 and replaced the previous law that dealt with youth justice in Canada, which was the Young Offenders Act. The process of dealing with youth accused of crimes and the punishments available are different than those of adults. While youth must still be accountable for their actions, the law takes into account that they are not yet developmentally mature. The law has special processes to ensure youth are treated fairly and places a greater emphasis on rehabilitation than the adult system. Here we can see some of the principles of the Youth Criminal Justice Act. The Act has a clear emphasis on the needs of youth as well as public protection. The Act protects the public by holding youth accountable, promoting rehabilitation and reintegration, preventing crime by addressing the root cause of the criminal behavior. The Act also gives emphasis to the youth by rehabilitating and reintegrating them into the community through fair and proportionate accountability and timely intervention and prompt enforcement. Let's look at the differences between youth and adult criminal justice system. Youth and adults are treated differently when they go through the criminal justice system. This section describes some of the ways the youth justice system is different from the adult justice system. When it comes to rehabilitation, the youth justice system emphasizes helping youth get the support they need to become law-abiding community members. This includes help with moving back into the community after serving a sentence in the custody. In the youth justice system, it is important for youths to take responsibility for their actions. At the same time, the system responds in a way that takes into account that their level of maturity is not the same as adult. While youth enjoys all the legal rights of adults, certain rights are given special protection in the youth justice system, such as right to a lawyer, right to privacy, etc. The youth justice system also focuses on completing the criminal justice process as quickly as possible, since a youth's sense of time is different than an adult's. Parents have a special place in the youth justice system. They must be notified of the actions against their children and given the opportunity to speak to justice officials. At court hearings, such as sentencing, parents are encouraged to support and help their children make positive changes. The Youth Criminal Justice Act states victims should be treated with courtesy, compassion, and respect for their dignity and privacy, and should suffer the minimum degree of inconvenience as a result of their involvement with the youth criminal justice system. Here we can see some of the terminologies we use in youth criminal justice system. Like adult facility, we don't call them inmate, we call them youth or young person. And correctional officers at adult facilities are called as youth service officer in the youth system, and managers are called youth service manager. Youth doesn't hold a criminal record but findings of guilt, and we don't address them as criminal but young offender. And also the institutions we don't call jail or prison, but it is called youth center. For example, I work at Roy McMurtry Youth Center, which is a youth detention center. Here, I want to do a small learning activity to better understand how the criminal justice system treat each person based on their ages. Jack is 18, Peter is 17, and Jimmy is 11 years old. One evening, the boys broke into a parked car. Someone called the police, and all three boys were caught. What happened to each of the boys? You can pick one of the following choices and put it in the chat box. All three boys were charged with the crime. Second option is two of the boys were charged and sentenced under the YCJA. One of the boys was sentenced as an adult. Third option is all three boys were treated differently. I'll give you 2 to 3 seconds to put in your answers on the chat box. Yes, most of them got the right answer. Option 3 is the right answer. Let's see how. Here, Jack is 18. He was charged and dealt with through the adult criminal process. Peter is 17, and so he was sentenced under the Youth Criminal Justice Act. A police officer took Jimmy home to his parents. The police told the parents what happened. Jimmy was not charged with a crime because he was only 11 years old. Let's look at the sentencing process in youth system. A judge requires information to make a decision. It is important that the judges know the circumstances surrounding the offense, the life circumstances of the youth, the impact of the crime on the victim, the gravity of the crime, and also the circumstances surrounding the crime. This information comes from a variety of sources, including police reports, witnesses, court reports, psychological assessments, and much more. When a youth has entered a guilty plea or has been found guilty of a criminal offense, the judge can impose a sentence that includes one or more of these options. First one is discharge. Where no conviction on the charges, the youth may receive conditions such as probation or an absolute discharge with no criminal record. Next is judicial reprimand, where a serious warning from the judge will be given to the youth. The other option is fine or compensation, where the youth may have to pay a fee, return goods, or provide other reparations. Next is community service, where the youth may be required to provide up to 240 hours of work in the community. The other option is conditional sentence or probation, where the youth will receive certain conditions that limit their behavior. The youth will be required to report to a probation officer up to 2 years. And the last is custody. In the youth facility, we have open custody placement and secure custody placement. Custody is the harshest form of sentence available for youth because it means removal of freedoms. Under the YCJ Act, other sentencing options must be considered first for all youth. When a judge does sentence a youth to be in custody, they must explain why other options were not chosen. There are a range of custody options for youth. This may include living in the community with a strict curfew, being under house arrest, living in a secure facility such as youth detention center, or open custody placement. In the custody setting, we take an approach of relationship custody, where the staff not only to work from a strength-based approach, but also engage with young people and develop a rapport that helps them make more positive choices In relationship custody approach, the core characteristics include empathy, respect, and genuineness. Next is publication of identity and youth records. The basic rule in youth criminal justice system is that there will be no publication of youth's identity. Publishing means communicating the information to the general public through any means, including social media. The reason for this rule is to protect youth's privacy and help them be positive members in the society. Labeling a youth as a criminal may have strong impact on the youth. It could impact their self-perception as well as perception of others. Publishing the identity of a youth, victim, or witness in contravention of the YCJ Act is a criminal offense punishable by up to 2 years in custody. Next is youth records. Youth records are information about a youth's criminal history, including all convictions and extrajudicial measures. Youth records are allowed to be kept by courts, review boards, people dealing with youth, and the police. But there are some consequences of having a record. Having a youth record may restrict the youth's ability to travel to a foreign country, participate in recreation or sports activity, to get a job, or to attend certain schools. A convicted youth may have a youth record for up to 5 years and sometimes even longer, depending on the offense. The access to youth records are restricted to the police officer, judge, youth victims, youth's lawyer, youth's parents or guardians, the attorney general of the province, the director of a correctional facility. Unlike adult records, which remain open for life, youth records are destroyed at the end of the access period, provided there are no further offenses. Generally, the access period lasts 3 to 5 years after the youth completes a sentence. For the most serious offenses, it will usually be 5 years. If it is a less serious offense, it will usually be 3 years. Let's look at the employment opportunity with the youth record. Employers can ask applicants for a criminal record check and youth have the right to refuse, but this will jeopardize the employment opportunity of a youth. Employers are not allowed to access youth records because youth records are not convictions. If a youth record is found during a background check, police must separate the youth record from the adult record. Police must give the report with the youth records only to the youth. Let's look at some of the programs available at Youth Justice System. We have healthcare in the youth center where the healthcare department will follow up with the youth if they need any medical supports. If a youth needs eyeglasses, we provide them. If youth needs dental care, we provide them. We also have psychiatrists visiting the facility twice a week, where for psychiatric assessment and for medication supports. There is a psychology department as well, where they provide individual therapy or sometimes they provide group therapy too. We have a spiritual life center where they offer Christian programming, Muslim programming, indigenous programming based on the religious consideration of each youth. School is one positive factor which the youth can achieve from a youth facility. The youth has the opportunity to go to the school building, which is inside the facility, from morning 9 to 3 to achieve their high school diploma. When a youth is already graduated high school, the social workers support them to enroll in post-secondary education. Since the youth is in custody, they cannot do in-person program, but social workers help them to enroll in online post-secondary programs. We also have recreation department where they offer rec activities to youth on the unit. And every day, each unit go to the gym for an hour for recreation activity. We also have library where youth gets the opportunity to go to library once a week and get the books they prefer to read. We also have few community organizations that come to the facility to do programs. Recently, we started a yoga program, dog therapy like Aral facility. At Roy McMurthy, we offer trades program for youth and fitness program. And in this festive season, they are given the opportunity to decorate their units, and the winners will get special prizes. Finally, let's look at the role of a social worker in the youth justice system. So in the youth justice facility, we have intake unit and regular living unit. When a youth comes to the facility, they go to intake and admittance area where healthcare department will go and screen the youth. Clinicians will go and screen the youth. Clinicians usually do risk assessment to see if a youth is on active suicidal ideation. If a youth has suicidal thoughts or active plan, we initiate a suicide watch for the youth and move the youth to the close observation area for close monitoring. Otherwise, the youth will go to the intake unit where they spend first 14 days. At this time, the intake social worker creates clinical admission report for each youth entering the center within 72 hours. The clinical admission report is the first step of the reintegration process for all youth. It includes information on criminal behavior history, family circumstances of youth, parenting style the youth received, mental health concerns, identified strengths, responsibility issues, and reintegration needs. While the youth is on the intake unit, he can receive either bail or be level 2 open custody or be moved to a regular living unit. So when a youth reaches the regular living unit, the regular unit social worker will provide clinical services and interventions to each youth on the unit. The social workers usually, their office is inside the unit for close proximity where the youth can access social worker at any time. The social workers maintain regular contact with probation officers. We also provide support to the families of youth through regular contact. Another role of social worker is to facilitate and coordinate referrals both internally and externally to support the identified needs of each youth. Social workers also provide clinical input to members of the case management team about the youth in their care. That brings me to the next topic, that is the case management model. The youth justice system uses an interdisciplinary case management team model to engage young person. So in this case management team, the social worker's role is to act as a case coordinator. Other core members in the team includes youth, parent, youth service officer, youth service manager, and probation officer. And supporting members include psychology, education, healthcare, recreation officers, spiritual care, volunteer, and community partnership. So social worker has, as a case coordinator, coordinate, schedule, and participate in case management and reintegration plan meetings. The first initial meeting is completed on the 30th day from youth's admit date, and the review meetings will be completed 90 days from the admission date and every 6 months thereafter. So this meeting is a collaborative meeting to discuss the immediate and future needs of a young person who is in custody or being released to the community. This is basically a plan of care for each youth based on an assessment of risk or need. I've included a diagram on navigating the youth criminal justice and mental health system. This is pretty much self-explanatory, so I'm not going to explain this because of time constraints. The presentation will be uploaded on MASWO YouTube channel, so you can go back and look at the diagram. I want to finish my presentation with a quote. It is important for us as a society to remember that the youth within juvenile justice systems are most of the time youths who simply haven't had the right mentors and supporters around them because of circumstances beyond their control. So as social workers, I encourage each one of you to be a right mentor, right role models to the youth around us. Thank you.
Thank you so much. Thank you so much for covering all the aspects, and I would say challenging all the social workers out there, especially your covering of the taking up the issue of the terminologies. That was really very good, because the background from where most of us come from, where we are educated. For example, we call a jail, but whereas it's a youth center and a justice system. So this is something of the terminology has its importance, and thank you for amplifying that today. The learning activity was really very innovative and educational also, I would say. And I think, as you said, most of them got it right. And that shows that we are all on the right track. And thank you for taking it up. The sentencing process, the youth record, the programs in the youth justice system, and most importantly, the role found and leaves a mark in this whole session, I would say. Thank you so much again, Anu, for taking this. We will go quickly into the question answer session. May I request the participants to take up questions during this session. This is a very good opportunity to take up questions. Anything you would like to ask the eminent guests who have been the eminent speakers for the day. Yeah, Abhilash, you can go ahead if you have a question.
So I have a question here. Can you please explain more about justice program mentioned in your slide? Is it something related to justice and mental health program coordinated by outpatient health clinics by hospitals? Abhi, you want to speak on that?
Maybe he's muted. Maybe you can take it up, Abhilash, if possible.
Okay. Good. Okay. So I believe in Ontario, if someone is having mental health challenges and they are not convicted of an indictable offense, so if it's a summary offense, they have an opportunity to go for a mental health court diversion. If it's only available if the Crown attorney, that the government lawyer, agrees with the proposal, and in order for someone to be eligible for mental health diversion, they have to agree the fact that they are struggling with their mental health challenges, and they also need to comply with the certain conditions set aside, put forward by the Crown attorney. So if they agree, they will be referred to a mental health court diversion program in Ontario. I would say there are many courts. They are employing, providing opportunity to certain organizations like COTA, John Howard Society, CMHA, to run this mental health and court diversion program in partnership with the criminal justice system. So if the public prosecutor, the Crown attorney agrees, and the both parties agrees with the condition, then these cases will be transferred to a mental health and justice worker. They are in the court, so they would agree to the conditions, and they will, in part of that condition, sometimes people will be asked to seek mental health treatment and undergo substance use treatment, or connect with the community organization they provide. So sometimes what happens is client will be referred to community organizations or any organization that provide mental health support. So oftentimes case managers, they work with the clients in the community, in a community mental health organization or hospital. Outpatient mental health clinic come in contact with such clients.
Thank you, Abhi. Kuriakos, do you have any questions?
Thank you.
Yep. So I have a doubt. So can I allow to visit a family while incarcerate, like in case of a death of a family?
Yes, if you get the permission, you can. If you get the if you selected for the temporary absence program, you can. Or sometimes we also arrange Zoom calls for them, like specifically if it's a death notification during the time of COVID, it was difficult for the TAP program to happen. So that time we were using the Zoom, but uh, either he could go out or no, he could have an online access to the viewing, or depends on the reason why he wants to get out from there for temporary absence.
I
Okay.
can also add how it is in youth justice system. So for youth, we don't allow youth to go into the community unless the youth is sentenced. If a youth is sentenced, then we can apply for reintegration leave to attend the funeral service. Otherwise, our spiritual life center will do a memorial for the lost ones.
So I can also add something to that. So the temporary absence program work with the adult correctional system. So what happens if someone's family member passed away, or they are in end of care life and they want to see? So the adults detention centers allow people to go out under temporary absence program, we call TAP, but with certain conditions. They won't be allowed to interact with any family member or anybody when they are TAP. They will be escorted by the correctional officers. They will be put in handcuffs as well as on shackles on their leg. They have to wear the correctional uniform, like the jumpsuits, and it will be a private visit. No family visits or anyone will be allowed, even if it's a funeral or if they are going to see their family members. They are in the end of care life. So that's how it works with uh, the adult institution. And also it depends upon the type of crime they are committed, the history of their behavior in the institution. So many factors play in a role to be able to get a TAP from an adult institution.
Thank you. Thanks for sharing that.
Hi, I have one question. So my question is that because you people work with different kinds of clients, and some of them might struggle to keep track of their appointments at times, and we often face that. You might often face that. So my question is that what happens if someone don't show up for their court hearing? As a social workers, what are your rules and how do you check that situation?
So I can answer that question. Like, and it's often a struggle. I work in a community health center. Sorry, community health center, and sometimes we make an appointment to see clients with they are transient or homeless, and then next time when they see, hey, you didn't show up for your last appointment, then client would say, I don't even know what day is today. So like, are you asking me about my priorities not to see a social worker to how to survive today? So what happens when like that's a different situation. We have that understanding. Criminal justice system don't have that understanding. They go by the rule. So what happens when somebody's don't show up for their court appearances? Sometimes if then the crown knows the client and they know that this person is struggling with the mental health challenges, and they probably give some leniency, probably wait for another day, and if not, there will be a bench warrant will be issued against that individual to arrest that individual and produce before the judge as soon as possible. So oftentimes when it comes to the court appearances, people don't need to show up in a court. Instead, they can just call their lawyer and tell them that, hey, I am not coming to the court today. Just let the prosecutor know that. Then they will postpone the hearing to another day. So that's a good idea, to just advise the client if they are not able to go to the court for a hearing. It's a good idea to just let their lawyer know about that. Otherwise, in most cases, a bench warrant will be issued, and the person will be charged with not complying with a court order or a promise to appear.
Thank you.
So we have a
Thank you,
question in
Abhi.
the chat. Despite the support given, what is the data about reoffending and the reasons for the same? Anyone want to try that?
That's a good question. So I would say probably 80% of people, like they come into various adult institutions, are repeated offenders or struggling with the recidivism. It's frankly speaking, we are working with a broken system. There is no connection between the institution and community. Many people, they are in adult institutions, struggle with some sort of struggles, probably mental health challenges or addictions. So because all of the institutions, adult institutions, are maximum security presence in Ontario, it's really challenging to provide the programs in a free and like in a very constructive manner in an institution. There are a lot of factors impact the move. So when it comes to an adult institution, the programming are not their priority. Security and safety of the institution is a priority. So oftentimes program staffs like social workers, addiction counselors, and any other rehabilitation of people struggle to have meaningful interaction with the inmates or offenders. So that disconnect between the institution and the community at the time of their release, what happens after that, the institution has not concerned at all about that. So that disconnect and lack of resources in the community for rehabilitation of the people who are released from the custody, I believe that that causes that issue. Yeah.
Thank you, Abhi. Thank you
There
so
is
much.
another question connected to the previous question. Is revolving door a challenge, especially among the youth? And what steps are put in for that? It is indeed a challenge. We keep telling the youth don't come back, but they keep coming back because of various reasons. It can be their involvement in the neighborhood group, or their life situation with limited support in the community. So we try our best to connect them to a positive adult in the community when they are released. If housing is an issue or mental health concerns, we connect them to the appropriate resources for the youth. And we give importance to education as well, because most of the youth who come to the facility will have truancy issues. So we connect to a caseworker in the community or a transition support worker with the youth, so that the youth can complete the education and apply for a legal job. So it depends on youth's needs and risk factor. We try our best to reduce the recidivism, but it's still a challenge. Yeah.
Thank you.
Any other questions which needs to be addressed? Anyone else? So if we don't have any other questions, let me just remind all the participants that next week we will be again having a session, and we have 3 eminent speakers lined up next week, and they will be Anju, who will be covering on social workers' role and responsibilities in correctional facility setting. Dia would be covering on the specialized units in correctional setting, and last but not the least, but the most important one of will be done by Bijo, who will be covering on the hiring process for social workers in youth justice and correctional settings. So it would be on December 2nd at 10:30 a.m. That is next Saturday. So we hope to see you all. Before we switch off, I would like to say that the session today on the social work in correctional setting reminds us that you are not just meant to survive life and jail. no, but to thrive in life and teach the world. That is what should be the reminder for reminding each social worker who is present over here. On behalf of MASWO, I would like to extend our heartfelt gratitude to the three speakers, AB, Abhilesh, and Anu, for taking time out from their busy schedule and giving a lot of purpose to this whole initiative, I would say, and the innovative way you handled it and the presence and active engagement with the audience has contributed significantly, I would say, to the body of knowledge for all the participants for today's event. My sincere appreciation to all the participants for their dedication, insights, the questions which you asked and the patience which you showed and the meaningful reminder that we have overseas participants as well today from CAPS them. And we look forward to the future collaborations and the discussions, which is scheduled on December 2nd at 10:30 a.m. So thank you once again to each of you for your presence and participations. Stay safe.